Well, thank you everyone for being here at the last part of the day. Try to give you some useful information. Can you raise your hand on who's from Texas here? Okay, we've got a few. Okay, most of this is with Texas law, but it's in general. We'll talk about some of the states that have community property, which is 8 or 9. And that usually, with what I'm talking about, Texas is a community property state, and that goes with that. But in general, we're going to be talking about what I call the Special Needs Toolkit. And this is just general information. I'm not your attorney today. I do a little bit of probate, estate planning. I've got a daughter with special needs who my wife and I have guardianship of. She's 29, so we've been into a lot of the same situations that you have been in also. The Special Needs Toolkit is a number of things that you as parents should be thinking about, regardless of what state you're in. Be sure you have your wills together, and if you have a child that's under the age of 18 and 19 in Mississippi and Arkansas and Alabama and 21 in Mississippi, then you should have something in your wills who's going to be the guardian of your child. That's extremely important. If your child is on, once your child turns 18 and if they're getting on SSI and Medicaid, then they can only have $2,000 in assets. Or if you get on the waiver program, which we'll talk about today, you need a special needs trust. With my daughter, we have a third-party special needs trust for some money that my parents gave her before she died, and she also is working a little bit, so we have a first-party special needs trust that keeps that money from hitting the $2,000 mark. Be sure you have proper estate planning. Our kid's going to take a lot of money to take care of, so be sure you get with a financial planner that does special needs, and very important. We'll talk about SSI and Medicaid, talk about the Texas Medicaid waiver list and the waiver list in the other states, and we'll show you why Texas is not a great state to live in as far as that goes. There's something we'll talk about in the letter of intent. Your support team, you're here today talking with other parents, and that's very important. Also, be sure to take care of your health and your mental health, because if we don't take care of ourselves, we can't take care of our kids. We talk a little, we talk about estate planning, special needs and elder care. Really, special needs and elder care focuses on what's happening now with your loved ones or your parents as they get older. And then estate planning is being sure that everything's set up where your loved ones that may be getting government benefits does not get an inheritance. And we'll talk a little bit more about that. Why do we need a will? Well, regardless of whether you're in Texas or some other state, it's going to distribute your property as you want it. If you've got a blended family, such as myself, I've got a 35-year-old son, my one marriage, and married to my wife now for over 30 years, and we have a 29-year-old daughter. So if I die without a will, then it's going to be distributed 50-50 to both of my kids, where in my will, which I have, I've got everything going to my daughter's special needs trust. My son's got a great job and doesn't need any money. He's getting the antiques, which right now he doesn't appreciate, but maybe down the road he will. But I've got a 10 by 30 storage unit with my mom and dad's antiques, which I have no room in my house, but I can't get rid of them yet. But, as I mentioned, be sure you have a guardian name in your will. In Texas, if you die without a will, and probably in some of the other states, you're going to die intestate, which that means the state of Texas will tell you how your assets are distributed. I've got a case in probate court where a mom died without a will, and she's got a 30-year-old daughter in Brookwood. under government benefits. So we've got to go into probate court and fix that issue where the young lady will not get any assets. Probably set up a special needs court-ordered trust with that. Valid wills in Texas, you can have a handwritten one. I would probably tell you to have a attorney drafted one if you've got kids with special needs or disabilities. And in Texas, as long as, and a lot of states do this, as long as your will is valid in the state that it was drafted in, it's going to be valid in Texas. Texas is a community property state. As I mentioned, the other community property states, Arizona, California, I know we have a lot of people from California in this convention or seminar, Idaho, Louisiana, Nevada, on and on. And then Alaska, South Dakota, and Tennessee has a odd law that you can either say you've got community property or not. Basically what community property is in Texas is that regardless of who's on the deed in your house, or and that was purchased during your marriage, you and your spouse have 50% interest in each. Separate property is what you brought into the marriage or what you inherited from the marriage. And in your will, you can divide 100% of your personal property, but only 50% of your community property, because that's all you own. What happens to a child if they die without a will? We've talked about that just a little bit, but the state of Texas is going to go to the grandparents first. I know that I had some great-grandparents, but some are better than others looking after my daughter, our daughter, as my wife would say, not yours. But be sure, you have that listed. I don't know how your state does it, but I would assume it's probably pretty close to what Texas does in some situations. So definitely have who you'd want to be the guardian of your minor child, or in our situation, guardianship of our 29-year-old daughter who we have guardianship of. Trust. Why do we have trust? Well, if you don't have any kids with disability or special needs, it may help you keep your assets out of probate or help with taxes. But with us, we normally have special needs trust that will take care of our kids' inheritances or money from our parents, so they won't hit that SSI and Medicaid $2,000 limit in assets. That's really the only reason that you need a special needs trust. We can do those inter vivos, which is outside your will. I've got one outside of my will because my parents gave my daughter some money prior to them passing. Or you can have a testamentary special needs trust in your will that stays dormant until you die, and then the assets or the assets going to your special needs child goes to that trust. In Texas and a lot of states, we have a first party and third party trust. The first party trust, special needs trust, is one that is the money from the beneficiary, such as a lawsuit, or in my daughter's situation, a little bit of money she makes working will go into that, or if you've got SSI back payments, that can go into a first party special needs trust. In Texas, if you're a divorced parent, prior to age 18, child support is the parent receiving it income, and once your child turns 18, that child support is income to the child with special needs. So what we try to tell the family law attorneys, most of them will hire someone like me as a consultant in a divorce case, is be sure you have some documentation in there where once the child turns 18, child support doesn't go through the Attorney General's office and to directly to the first party trust. So regardless of what state you're in, that's probably going to be the situation where once they turn 18, that's going to be counted as income. Trust, like I mentioned, we use those to keep the assets away from our showing from SSI and Medicaid. Trust will also keep assets out of probate. Probate is when you die, you take your will to probate court and go through the procedure, and that will give you an executor the legal right to dispose of your assets. So we can put stuff into a living trust or a special needs trust, and that's outside of probate. The other ways to keep assets out of probate is if you've got a life insurance policy or a retirement fund, you can name beneficiaries to those, and that actually keeps it out of probate. If you've got checking accounts and savings accounts, you can have POD on those, which is payable on death, and that keeps it out of probate, so it makes life a lot simpler. There's different types of a special needs trust. The self-settled is the first party that has to be funded before age 65. There's something in Texas called the Arc of Texas Pool Trust, and that's a fairly unique trust where if you've got, if you have someone with special needs or getting old, you don't have any family members that will be a trustee, then you can put that money into Texas Pool Trust, and they can take care of that for you. And then the third-party special needs trust, which is one of the ones that I have, and basically it's what it says. Third parties will put money into that trust. The one thing with special needs trust, they cannot pay for food and lodging. That's what SSI pays for. So you can work around that issue, and I also cannot give cash to the beneficiary. And the way to work around that is that you can move that money to an ABLE account from your special needs trust, and then the ABLE account can pay for food and lodging and give cash to the beneficiary. A lot of this comes into effect when these kids grow up and move into an apartment, and mom and dad is helping to pay for that apartment. And then what SSI is going to do is you're giving your child in-kind support, and your SSI is going to be reduced by 1/3. A lot of folks come to me and ask why they're not getting the $914 a month, and in most cases they don't have they're getting in-kind support to their loved one who lives with them. And the way we can get around that is for them to do a rental agreement with mom and dad once they turn 18, and then instead of your SSI being reduced by 1/3, you're going to get the full amount. First party trust, we talked a little bit about that, but it can really needs to be funded before age 65. And the main differences between a first party special needs trust and the ABLE account and the Texas pool account, ABLE account, you've got one in every state, so this is going to be the same whether you're from Texas or not, is that they've got Medicaid payback. What that means is that once your child turns 55 and Medicaid after that, and when they die, then Medicaid can come back after the first party trust or the ABLE account and get reimbursed with that. So that's why we tell everybody to put as much money as you want to into the third party special needs trust and then move it to the ABLE account. Now you may have children that may be living in a group home, or someone like Brookwood here in Fort Bend County, and that's going to cost between $2,500 and maybe $6,000 a month. And basically what we tell clients is to do is don't worry about the ABLE account, just pay that money each month out of your pocket and lose that 1/3 from the $914. It's really not worth your time and effort in putting money into an ABLE account for many, many years before you start spending it, and I'll tell you the reason behind that. Third-party trust is not subject to Medicaid payback, so you can put as much money into it as you want to. I personally haven't funded my third-party trust. Of course, everything goes to my wife first, and then if we both die in an accident, then my third-party trust gets everything from my estate. And it's not subject to Medicaid payback, and you can also have your beneficiary is named in that, which you can with the first party trust, but Medicaid may come get the money first with that. I normally tell parents, and as I mentioned, I haven't funded mine yet, is once you put money into it, you can't take money out except for your beneficiaries. So in my situation, mine will not be funded until I die with my life insurance and 401k and stuff. I'll also probably move the house in that for a time being, and then we'll probably end up selling that house and the money going back into the trust. As I mentioned, the special needs trust cannot pay for cash, give the cash to the beneficiary, cannot buy food, and cannot pay rent because that's what the SSI is supposed to pay for. And you also have to be very careful. If you put a house into a special needs trust, you also have to fund the ABLE account in order to pay for some of those services that a house has to have. I won't go through this, but it basically, you can pay for anything but food, lodging, and cash. So it's you can actually pay for a vacation out of a special needs trust for the beneficiary and one adult that will be looking after them. So it's pretty good. Guardianship in Texas. Once these kids turn 18, and that's the situation, age and majority in all states except Alabama and Nebraska, and it's 19, and in Mississippi it's 21. So what that means is that everything that you were doing for your loved one prior to age 18, you can't do it anymore after they turn 18 unless you either have guardianship, full or partial, or have a medical power of attorney or power of attorney signed by your loved one. In Texas, those two documents, you have to have the cognitive ability to understand what you're signing. So it's really A or B, A, power of attorney, medical power of attorney, or B, guardianship. In Texas, we do have something called the supported decision-making agreement, and that is an agreement that if your child or loved one cannot do a power of attorney, a medical power of attorney, and you do not have the money for guardianship, then that will hold you over until you can save enough money or get with a nonprofit to help you get guardianship of your loved one. Unfortunately, it says decision-making agreement, and we'll go over that. What that means is kind of misleading in the off that. One thing I will say, and I run into this all the time in my practice, where kids come to me and say, well, Mom, in a nursing home, Dad died a couple of years ago, and he was the agent on her power of attorney, medical power of attorney. What do we do now? Well, unfortunately, if Mom has dementia or does not have the cognitive ability, then we have to file guardianship for the parent. I was very lucky with my parents. I was on all their bank accounts and had power of attorney and medical power of attorney on them. A lot of your parents may not want you in their business if you're lucky enough to still have them with you. So you can always tell them that you can have the stipulation in your power of attorney and medical power of attorney that until they're incapacitated, and you can tell Mom that it would have to be by 2 doctors if she wants it. And that will allow you to take care of them if they do become incapacitated instead of going forward with a guardianship. Guardianships in Texas, full or partial. Guardianship of the person is what we have on our daughter. She basically doesn't have any assets. And what guardianship of the person does is give you all the rights that you had prior to age 18. So with that. Guardianship of the estate is usually done when we have older people with assets. There are situations if you've got a 529 account or a UTMA account, which is the underage minor account, which is across all the states. Then a lot of the guardianships, you'll have to get guardianship of the state. Montgomery County is the only one of the surrounding counties here that will allow you to have a UTMA account and then prior to age 21 to cash it into a trust. But any of the other counties will make you do guardianship of the state. So what I usually tell parents is let's move all that money somewhere in a trust prior to applying for guardianship. Temporary guardianship is if you've got an emergency that someone needs guardianship of, or if you live out of the country and your successor guardians may have to get a visa to come back into the country, then we can have a neighbor do a temporary guardianship until they get here, or even if they're out of state. Because how do you get guardianship? You still have to go through probate court and do it. So I mentioned before is have a guardian named in your will. The way that works, if my wife and I both die, then my son is the guardian of his sister. Their name is named in my will, and what he would have to do is take our death certificates along with the will, naming him as guardian, and go through probate court or the normal probate process, and he would get guardianship of his sister. So that's fairly easy, and it's very helpful to name a guardian in your will. Guardian, as I mentioned, can be full or partial. We have full guardianship of my daughter. She's 29, so that was 11 years ago. She's improved so much, if we were getting guardianship today, it would probably be a partial. So we've got a picture of her at the end, and we always like to take her to our resource fairs that we go to and show parents that these kids do grow up and tend to deal with their disabilities a lot more than they used to growing up. In Texas, we have to have what we call a physician certificate, and basically what that certificate is, it tells the court how the disability affects everyday life, and that's filled out by your physician. Who can qualify for guardian? Almost anybody, as long as they don't have a criminal record. I have had a parent that had a drug conviction 30 years ago, and we basically came in and got letters of reference and gave to the judge, and he didn't have a problem with that. I do mention that if you've had a DWI past 4 or 5 days, a judge in the surrounding counties will not give you guardianship of your loved one. A couple of years ago, I was the attorney ad litem, and I'll tell you what that is later. I was representing the young person, which we call a ward in Texas. And the parents we were already at the hearing, and the judge, of course, they have the criminal record background checks on the parents, and the judge brought up to the father that, didn't you have a DWI 2 years ago? And he said yes. And the judge basically said, well, sir, you're not going to get guardianship of your loved one. Come back in 4 or 5 years, and I'll consider it. So I will say that all these judges in the surrounding counties are fantastic. They look after the best interest of the child. Not what mom and dad wants, but what is in the best interest of the child. And I was actually pretty impressed with that. If you're an elderly person, the spouse can be the guardian. The mom and dad can be co-guardians in Texas, or a biological parent and step-parent can be a co-guardian in Texas if the other biological parent signs a waiver agreeing to that or is deceased. That's about it. Everything else is pretty, you can't owe any money to the ward and be guardian, and other than that, that's about it. Guardianship steps in Texas, you can file 180 days prior to the 18th birthday. I normally tell my clients to do that, where we can get it in the system, get the attorney ad litem appointed, which is the attorney that the court appoints to look after your loved one, and get everything going and get a hearing date. As we approach the Thanksgiving holidays and Hanukkah and Christmas after that, then the courts get all backed up. So if something comes up in that time, we're looking at the end of January, and that's been happening year in and year out. With that, won't go through a lot of this since a lot of you are not from Texas, but basically, if you have a guardianship from another state and you bring it to Texas, that's fairly easy to transfer that guardianship. In Texas, if you move to a different house, you need to tell the court, and if you move to a different county, we have to transfer guardianship. I was living in Harris County the first couple of years with my daughter, and then we moved 2 miles across the county line and had to transfer the guardianship. So just be aware of that if you're doing things like that. Guardianship of the person, basically we won't go through this, but it's what you're doing for your loved one now prior to age 18. Really nothing else, but what it does, it gives you the ability to make dental, medical, psychological approval for different things. We had one of the situations that we had recently is that for whatever reason the parents didn't get guardianship of their 18-year-old girl, and about a year later she was going to get a non-emergency operation, and since they even a power of attorney wouldn't have helped here, but she did have special needs, and she got all the way rolling her to the operating room, and she said no. So they couldn't operate on her anymore. It was the tonsils coming out. So guardianship would have allowed her to continue and get her tonsils out. If it's an emergency, the doctor's going to do whatever it takes to save someone. But if you have guardianship and your child with special needs or disability doesn't want something, then you're out of luck on that. Okay. I also have a number of clients, it probably doesn't apply to any of you, but I have a number of clients that have adopted kids from the Eastern Bloc countries, and a lot of those kids have fetal alcohol syndrome, which is a deal where during gestation the mom was drinking. And these kids can be very high IQs, but they have tremendous anger issues all the time. And what we try to tell these parents is you may want to get a partial guardianship instead of giving these kids a power of attorney, a medical power of attorney, because if they wake up one morning and mad at mom and dad, which happens a lot, and they tell the right people, those power of attorneys and medical power of attorneys go away. So that's something to think about. Main thing about guardianship of the state, it just has a lot more reports that you have to file with the court. In Texas, it's pretty crazy. You have to hire an attorney each year to file your financial report. With a guardianship of the person, you just file a regular report each year, and you as the parent can do that. So really a big difference. And in some situations, if you've got the individual has a huge estate, then a lot of times you may have to get court approval to spend money from that guardianship of the estate. In Texas, we also look at, and I'm sure they do this in all states, but we look at the alternatives to guardianship. In 2017, they passed a law requiring all attorneys to do that, although we do it anyway. And as I mentioned, there's the power of attorney and medical power of attorney. The HIPAA release is allowing someone to get your digital and paper medical records. We'll talk a little bit about the ABLE account, talk about the supported decision-making agreements. Then we've already talked about the special needs trust. I will say that universally, there's something called the Cates Law. If you've got elderly parents that still want to drive, you can quietly take the department of that does the driver's license and tell them to give your parents a new driving test. And that's one thing that they came out with that may be very beneficial to a lot of us. I don't know. I don't know. Luckily, good question. Sorry. Statutory power of attorney, as I mentioned, the individual has to have the cognitive, and this is Texas statutory power of attorney. You have power of attorneys in all states. It just depends on what your state requires. But in Texas, we require the cognitive ability to understand what you're signing. I've been practicing since 2015. This is my second career. I was a geologist for 40 years. But since 2015, I've probably only done 3 or 4 power of attorney and medical power of attorney for kids with special needs. That's probably 50% of my clients are in that category. But normally what I do, I take the young person into a separate conference room away from mom and dad and ask them if they understand what they're signing. And I don't do a lot of these. I have a cutoff of 70 IQ in my office, so if your loved one has below 70, then I won't even attempt to do that. But normally, when I first started out, I had mom and dad in the same room as the kids, and of course they looked to the left or right to see what yes or no they'd be telling me. Medical power of attorney, basically the same thing. A lot of times when I do the estate planning for older people like myself, not you guys, but you know, you can do the power of attorney either at your incapacity or now. I actually have mine now with my wife. If I don't trust her now for 30 years, then I probably can't trust her. But what that allows her to do, if I have a credit card in my name or a bank account in my name, it allows her to go get information or change stuff. But it still doesn't override my say-so with that. And what I was bringing up on the medical power of attorney, if you have one of those, which you should with your spouse or significant other, be sure to have those valid now. My mother-in-law was in an accident during the height of COVID, and she was taken to a hospital, and she was about 84, so she was a little groggy anyway. And if my wife had not had the medical power of attorney on her mom, of course she was talking to the doctor from the parking lot, she wouldn't have been able to do anything. And in most cases, her mom didn't remember or understand what the doctor, she's supposed to be telling the doctor, so it's very helpful. Supported decision-making agreements. This is Texas document only. I haven't heard of any of these in the other states, although I don't look at other states very much. But even though it says supported decision-making agreement, it's really assisting your loved one to make a decision, and he or she has to make the decision. What this does is that once our kids turn 18, you're in the ARG meetings in your schools. This will allow you to go with your child to those meetings, even though you may not have a guardianship of them, allow you to get in doctorate offices and other things. But what it does in a lot of situations, we know how our kids understands things, and it will allow us as a parent to explain to our loved one what the meeting's about and what the document they're signing is about. We talked about the ABLE Act. When it first came out, Texas did not have a debit card, so we had a lot of people going out of state to the ABLE Acts in other states. You can only have one ABLE account, so in those situations, if finally Texas woke up and got a debit card, but Texas is probably just as well if you live here to get an ABLE account. But what that does, as I mentioned, allows you to give money to your loved one in cash and also pay for food and lodging with that. You can only put $17,000 a year in an ABLE account. That's actually the gift tax rate. And you can have up to $100,000 in your ABLE account before SSI sees it. If you got a 529 account, if you don't have any other children or cousins or whatever that can use that, then you can move the 529 money over to an ABLE account, but unfortunately you can only move $17,000 a year. So that's why I was telling you about if you've got a loved one living in a group home or in some place like Brookwood that costs an arm and a leg, then you might as well just pay for it yourself, because having to put that much money ahead of time in an ABLE account is probably not worth the effort in doing it. Again, the ABLE account, the only drawback is that it has Medicaid payback. So what I tell parents to do, if they are funding an ABLE account, figure out what your monthly costs are in paying out for your loved one, and just put that only a couple of months in there for them. Again, just showing you, and I've actually got some, if you're in Texas, I actually have some document I can give you from this presentation. Hopefully you've got it in your package anyway, but this just gives you the differences between the ABLE account and special needs trust account. I normally tell people don't put money in an ABLE account unless you have a reason to do it. Set up a special needs trust account, although special needs trust account will cost you money to set it up. But again, it doesn't have Medicaid payback, and you can always move money into an ABLE account. You can have as many third-party special needs trusts as you want. I have a lot of divorced parents that their side of the family will set up one special needs trust, and the other side of the family will set up another one, and that's great. Even grandparents can set up a special needs trust, but what I tell everyone is be sure the trustees are talking to each other, because what we don't want to do is for one trustee to maybe not understand what you can and cannot pay for, and pay for something and mess everything up. So that's my only drawback in doing separate trusts for different parts of the family. The Arc of Texas, this is strictly for Texas, but that's what we call a pool trust. It actually has two separate first party and two separate third party trusts within that, and basically how that is used is if you don't have any other family left, you're getting up in age and someone's got to take care of the money for your loved one, and they do an excellent job in giving out the money for looking after someone. Also in Texas, we do have, I know in Fort Bend we have the Brazos County Guardianship Services. In Harris County we have the Harris County Guardianship Services. So if you have a loved one or know someone that does and they're getting up in age and do not have any family members to look after your loved one, then that is an alternative way to go about it. And then in Texas, there are also private guardians, so that's at least we can have someone looking after our loved one, because at the end of the day, that's what we worry about, what's going to happen to our loved ones when we're gone. You know, my wife and I had a conversation about a year ago with my son, and of course he has a life of his own, but he did say he'd look after his half-sister, but you never know. And we just pray and hope that they'll be taken care of and not put into some facility with that. We developed with my daughter, and we actually sell this in my office, but you can actually get it online as a letter of intent. Our letter of intent is 75 pages, and basically what that does is cover everything about my daughter that you can think of. We have her personal information, what she does in the morning, what she likes to eat, her doctors. She's got 5 part-time jobs, so what time she goes to those jobs, or, you know, who are her doctors' names, what are her life insurance, her policies. And what this does is that if something happens to my wife, I can read this, and because we have everything segmented with my daughter, she takes care of some things such as SSI and Medicaid and the doctors and stuff, and I take care of everything else. But, well, I wouldn't tell her that, but some of that I don't pay attention to. So that would be very beneficial if something happens to her. I can sit down and read that document on the areas that I want to know about in about 45 minutes and know everything about my daughter. My son lives in Alabama. He sees his sister a couple of times a year, but he doesn't know what's going on with her. And if my wife and I die in an accident, then he can take that, or my mother-in-law, who's getting up in age, can take that and know everything about my son, his sister, or my mother-in-law, her granddaughter. So that's very important. You can get a loose leaf notebook and put that together. But I would stress to all of y'all, if you have kids, have something like this, because we take it for granted on what we know, because we live it day to day. and then someone that doesn't know our kids, they would really need something like this. So I think it's extremely beneficial if you don't have this already taken care of. All right, SSI and Medicaid. Where do I start? Prior to age 18, it's based on the parent's salary, unless you've got MDCP, which is the Medical Dependent Waiver Program in Texas. And that is not based on the parent's parent's salary. Once these kids turn 18, it's based on their disability and how it affects gainful employment. That's the key word. Normally I have parents call me up and tell me they've been denied at age 18. Well, most of the time it's because they just sent in the medical records and didn't do a separate document saying how that disability affects gainful employment. It may be a no-brainer, but you've got to have that document in there. The other weird thing about in Texas, once you apply for SSI, they're going to send you a denial for SSDI, which is disability Social Security. You didn't even apply for that. And a lot of parents get that into the mail and wonder what in the world's going on and think they've been denied SSI. But that's just part of the system in Texas. Hopefully in your state they don't do that. Again, the child can have only $2,000 in assets, and that's why we have the Special Needs Trust, Medicaid, and all of that has a 3-year look back. And so we can't move anything within that period of time. So that's why we have it put in Special Needs Trust, or in our will saying that we'll go to a Special Needs Trust. Be sure that, as I mentioned before, don't name your child per name in your will. In ours, we have some things going to my son, and then the rest going to my daughter's Special Needs Trust. We have the name of the Special Needs Trust for the benefit of my daughter, Caitlin Handley. We do not name her verbatim. We can go into probate court and fix that, but a lot of time and effort. So that's how we have everything done in our wills, as I mentioned, in our life insurance policy, and our 401k, and all of that. I get a lot of calls from kids, mom and dad's in a nursing home, or dad's died and mom's in a nursing home, and how do I pay for that? I actually had a call this afternoon while I was waiting on 4:30 to get here. And what happens is that your medical insurance does not pay for nursing homes. And so the only way to pay for that is long-term care insurance. I've got that. I got that right after my parents went into a nursing home. Unfortunately, the financial institution I've got mine with is not doing well, but at least we'll help somewhat. If you don't have that, then that money is going to come out of the estate to pay for mom's nursing home. And what we can do, a lot of law firms can go in and look at the assets and see what we can do to move those around. You can have a home up to $688,000 in a car, so mom can keep her home. And then if the mom is at home and dad's in a nursing home, there's other things that will allow your mom to get money. If dad's making too much money from retirement accounts and all of that, we can move that money into a Miller Trust or Medicaid trust, and that will qualify him for Medicaid. So we can mess around with some of that. If your parents have millions of dollars in an IRA that's in required minimum distribution, that does not count as an asset. I'm not sure why the government still allows that, but it's a great deal. So, but a lot of the financial planners do not understand that. My mother-in-law had just moved some money around and out of one that was in RMD, and I wasn't messing with that because it was my brother-in-law's duty to take care of the financials for my mother-in-law, and I politely told the financial guys, do you know about this? And he said no. So, if you've got parents with money and anything's in RMD, let it go, because it's really will help you with Medicaid going forward. And Medicaid, you have to have the physician's deal putting you in a nursing home, and then they also, as I mentioned, will look after your assets and also, the monthly income. If you've got assets, we can move those around. We can put those into an annuity and pay the spouse living at home, and that's presentable. So there's a lot of things we can do to save you a lot of money from spending everything on mom and dad in a nursing home. Okay, Medicaid waiver program. The first 5 ones are some of the main waiver programs in Texas. There are different names in other states. Most of them come under the 915C, whether you're in Texas or some other states. Unfortunately, in Texas, we have a 15 to 7-year waiting program. And my daughter, we didn't find out until age 14 for her. So she's still 5,000 on one list and 12,000 on another. What I did was, and this is what happens in Texas. Over 2022 and 2023, they're going to only allow 1,549 people to get on the waiver program. 5 minutes, okay. So very important to get it on early. This is wherever your state is. If you're in the light blue, you're in good shape. There's really no waiting in California and some of the northeast states. In Texas, again, 15, 17-year waiting period. Running out of time, so this graph on the left, well, the numbers on the left are that map you just saw, and regardless of what you see, Texas is way worse than any other state as far as the waiver program. The numbers on the right are what the Texas Human and Health Services run, and of course they're about 100,000 less than this particular group that did the survey in 22, but still the magnitude is the same. And in Texas, these are the ones that are on the waiting list. We have just, my wife got together the Arc of Texas and put forth a bill in the House legislated, and it just got passed that we're asking all the school systems that when these kids are diagnosed with a disability, that they are referred to the LETA or the mental health group in the county that services you, where they can get you on the waiver list. Right now it's passed the legislator, it's stuck in the Senate in the Education Committee, which we don't think is going to meet this year anymore. So we're going to get back on it next year, because you're required now at age 14 to tell the parents about the waiver program. So that's way too late, because if you tell someone at age 14 in Texas, they're going to be in the 30s or early 40s before they get the waiver programs. We'll skip that. We talked about the 529, the UTML account. Talked about life insurance and that. Okay. We're about in here where you might have some questions, but that's Team Handley, my wife on the left, my daughter in the middle. We always like to take her to as many fairs as we can to show other parents that they do grow up. We had one fair about 2 years ago, right before COVID. We were very busy, and she was on one side of the table, and my wife and I were on the other. And you never know, she has short-term memories, which is terrible. Once you get it in, it's great, but we're still trying to figure out how to get it into her. But she was over there talking to a potential client, telling them about wills and special needs trusts, and we looked over there, and she was saying exactly what we'd been saying. So you never know what your kids will learn or hear and take in from you, but she's a blessing in disguise. The little bitty things that our kids do compared to a normal child, if I can even use that word, it just brings a smile to our face. So we always like to show her off as much as possible with that. Well, thank you very much. If there's any questions, I'll be glad to answer them.
Hi guys, I am so grateful. Thank you so much for all the information. We are already at the time for the memorial, so if anyone has any questions, if you want to ask him, but I will be putting the mic down so you can come up and ask him, but I don't want anyone who wants to start to attend the memorial tribute to miss it at all. So it is starting right now. And the Boulevard Ballroom is back down the hallway. If you pass the elevators, they're on the right.